All right. So, recording started. Welcome to the Maine Planning Basics webinar series. My name is Tom Mariola, and I'm a senior planner with the Municipal Planning Assistance Program at MOCA. These monthly webinars are intended for those that are new to the planning profession. A reminder that these sessions are recorded and posted to our website, and I'll post a link to that shortly. You will notice the last couple sessions haven't been posted. MOCA is, I think, determining if they're going to have a YouTube page. So we post them on YouTube and they get linked to our website. We'll catch up on the postings as soon as that's sorted out. Our next session after today is planned for Friday, March 6th. Please pass along any topics for future meetings. Right now, we have two possibilities, or at least ones that have been thrown out there. One is the new Solar and Energy Storage Handbook that's developed by the Maine Department of Energy Resources. And then another one that someone threw out a few months ago about abandoned, discontinued, and lost roads. But I know you guys got more in you. We got to come up with some new topics. Today, we welcome Brenda Kielty, an Assistant Attorney General and Public Ombudsman, as well as Eric Stout, a MaineIT, FOIA, and Litigation Technical Coordinator. Brenda has been in the Office of the Attorney General for 15 years and in the role of Public Ombudsman for the state of Maine for the last 13 years. In that capacity, she provides information and training to both local and state agencies on how to comply with the Freedom of Access Act. Brenda provides informal dispute resolution services to agencies and requesters. Eric Stout, thank you for joining us, is the MaineIT, FOIA, and Litigation Technical Support Coordinator for the State of Maine, Department of Administrative and Financial Services. Thank you for joining us. Brenda and Eric, you can go ahead and begin.
Great. Thank you so much, Tom. Hello, Eric. I'm glad you're here. And I'm inviting Eric to just jump in at any point where his technical expertise might be helpful in our discussion today.
Sorry, Brenda, before you get going, would you prefer the questions wait to the end, or would you like folks to just toss questions out if they have them as they go, or what's your thoughts?
I prefer a more conversational format. Okay. So if people want to let us hear their questions, that's fine. And if it's something that needs to wait to the end, we'll just defer. But otherwise, I'd like to have a conversation. I am using a PowerPoint today just to structure the beginning of our talk. But, you know, your questions are why I'm here. So hopefully we can get to all of those. My contact information is on this slide. If at any point in your capacity working for municipal, regional, or state government, you have any questions whatsoever about public records or public meetings, I'm here as a resource, so feel free to contact me at any time. And also my understanding is today we're going to talk about FOA for maybe 45 minutes to an hour. And so this is a pretty abbreviated and fast baseline review of the law. We can't possibly get to every question that could ever come up. So I really do encourage you, if this raises questions for you, we're on the right track, but it's not going to answer everything. So today I'm just trying to structure our talk by giving you a pretty basic understanding of the legal framework for the Freedom of Access Act, who it applies to, and what are you responsible for, are really the big questions, I think, because like any of us, we're busy and we want to know, what do I have to do about this? So hopefully we'll help clarify that. The Freedom of Access Act is a procedural statute. It has steps, procedures that need to be met in order to comply. So we'll talk a little bit about that in the context of both public records and public meetings. And then hopefully, hopefully some of the emerging issues and things to look out for. In two areas I want to be sure to talk about a little bit is records management and the role of AI in FOA, which has really just exploded in my world recently. So let's start with the underlying principles of the Freedom of Access Act. And in the law, the Declaration of Intent really lays it out, that the actions of government are to be taken openly and records of those actions to be open, and the deliberations conducted openly. I mean, it's pretty simple and it's pretty broad. Also, that this law has to be interpreted liberally, which means when there's a question of whether something that government is doing or records of government, if there's a question about whether it should be confidential or it should be available to the public, it's always going to fall on the side of being available to the public. The Freedom of Access Act is state law, and its corollary on the federal level is FOIA, or the Freedom of Information Act. So when you hear about FOIA, this is a federal law that only applies to federal agencies. So FOIA does not apply to our state and local government. What we're looking at is the Freedom of Access Act, FOA, which applies to all levels of government in the state of Maine for state agencies. And the law covers two areas, the public records and public proceedings. So on the public record side, this of course is always a question is the record that I have in my hand something that is going to be subject to FOA? Is it a public record? And the definition of public record is very broad. It can be in any format, in the possession or custody of an agency or official of a state or political subdivisions. And by political subdivisions, that means our regional and local governmental subdivisions. Received, prepared, or containing information related to the transaction of public business. So basically, any format in the possession or custody of the agency or official concerning the transaction of public business. Those are the three elements that need to be present in order for the document in your hand to actually be a public record. On the public proceedings side, the meetings, these are meetings of bodies that are subject to the statute, and the content has to involve the transaction of any function affecting citizens. And this also applies to subcommittees and task forces and smaller subdivisions, whatever name a commission or a committee might happen to put on those task force or working group or subcommittee or whatever. So you can see that the Freedom of Access Act is meant to be broadly applicable to government on all levels of government in the state of Maine, and broadly covers proceedings and records, but it doesn't cover everything. And it's important to realize that there are exceptions and things that simply don't come under the FOA law. And I think the other thing that's important to consider is the volume of records that government either creates or holds. And I think it's fair to call government a storehouse of information. There's just a constant flow of data, of new records, of new information. And within this storehouse, individuals manage the data and records. So certain people have custody or responsibility for certain kinds of records. And I like to say you curate and convey. You're managing these records, you're creating them, you're organizing them, you're handling them, and then sending them wherever they are supposed to go. And it's really a core function of government. This is not something extra that we do. Every agency is dealing with this core function. And most of the time, the information that we're providing to the public does not trigger the Freedom of Access Act in any way. In other words, we're in the business of providing information. So there's, more often than not, requests for information regularly occur in the ordinary course of business, and the Freedom of Access Act procedural requirements never come into play. But a specific FOA request for information does trigger those requirements. And this is really a small segment of the flow of information that comes in and goes out of government. So we want to make that distinction between what kind of request is going to trigger a FOA compliant response and what kind of request for information simply goes down the communication policy track and is dealt with without ever dealing with FOA. So in terms of compliance, again, I just really want to make sure people have this in their mind that compliance with FOA is only an issue when FOA has been triggered. And so in these many, many, many uncounted instances where you or your agency are just simply providing information to people, answering questions, performing just all this information sharing in the ordinary course of business, FOA is dormant. It doesn't affect any of that. But when something triggers FOA, usually it's a very specific, FOA request. Maybe it cites the statute, making a request pursuant to FOA. Then you're on a different track and the procedural steps have to be complied with. So just to review, because here we're creating the parameters for public records, very broad definition, any format, any medium, in the possession or custody of the agency or official or employee or contractor, perhaps. There's some questions around that, how far that extends, but in the possession or custody and concerning the transaction of government business. And there is no limiting case law defining government business. So since we have to interpret the statute broadly, we usually interpret that very broadly. Now, we have this great mass of potentially public records, but this principle of openness in government, of accessibility to the records and the meetings of government, is balanced on the other side with the need to protect confidentiality. And it's a little bit of a knife's edge for government agencies because they have to honor both of those extremes. And so FOA is not open-ended in the sense that sometimes people refer to it the right to know law. And I don't like that because there's not a right to know everything. There's a right to access to public records. And although it's defined broadly, it's not all encompassing because on the other side, we've got to protect legitimately confidential information. So there are many, many, many exceptions to the definition of public record. They're not all collected in the same place. It very much depends when you're looking at a record, what kind of potentially statutory confidentiality might apply, some contextual situations, potentially privileges. So it's actually a fairly complex process in many instances to determine what confidentiality applies to a particular record. And I just took some examples and started a list here just to give you a sense of how varied the information that might be subject to confidentiality is. I mean, some's really obvious, social security numbers, of course, but there are many, many other things that are very particular, and it may be in a statute somewhere. But like I said, all of this is not collected in one place. And if you have questions about confidentiality, that is entirely reasonable. So again, let me take a breath and review. We're talking broadly about the concept of public access to the workings of government in the sense of the records, the public records of government and the public meetings of government. And now we're focusing on the public record aspect. So again, a person can make a request for information that is not a FOA request. It's just submitted in the ordinary course of business. But if it is a FOA request, and I recommend that requesters always cite the statute just to be clear that they want to trigger the statutory requirements, what could that requester expect? And maybe this is you. Maybe you're going to make a FOA request, or you have made a FOA request, and you want to know what can I expect? These are the procedural steps. The government agency has to acknowledge receipt within 5 working days. That's a really quick turnaround on receiving a FOA request. So there's a moment in time that agencies really need to be alert. The requester can expect a denial or at least a preliminary denial also within 5 working days of receipt. Oftentimes the search for records in the review hasn't even occurred within 5 working days. So the agency can just say, once we've collected the records and reviewed them, if there is any confidentiality, we'll issue a denial then. But again, 5 working days comes and goes really quickly. And the agencies need to be alert to this. The requester can expect an estimate of the amount of time it's going to take and the cost. That's a good faith, non-binding estimate, which can be amended. The agency has to provide the records within a reasonable amount of time. So in the state of Maine, although there's been legislation and proposed legislation to change this and maybe make a hard time limit, that has never passed, and it remains a reasonable amount of time, which depends on the circumstances. And then the requester can appeal a denial of records to Superior Court within 30 calendar days. So the statute provides a judicial remedy, and the appeal, like let's say your agency denied a request based on confidentiality, there is no internal administrative appeal. For instance, that requester might come back to you and say, ask for a reconsideration or ask you to, I don't know, send it up the chain or whatnot. And while you may determine that those steps are in the best interest of your agency and the requester, that's not required by the statute. The statute only provides a court appeal, and it's directly to Superior Court.
Brenda, before you go on to the next slide, I just wanted to stop you before you go to the next slide.
Yeah.
I had one question, and then there's 2 questions in chat.
Yeah.
My questions directly, I guess, related to the slide or what you were talking about right as you were leading into the slide is, and I can imagine this happens a lot more with towns, but what your feelings are on when, say, a resident makes a request, appears to be or is about to begin a FOIA request, request, and what are your thoughts? Sometimes I'll get a resident that'll begin sort of hint at it, right? Or say they want to make a FOIA request, but then I'll say, well, I'll tell you what, I'll just get you the information in the next 10 minutes. Does that work? Right? Like, can you talk them out of it just because we have it at our fingertips and it might be more cumbersome for them to go through the process than just have it by the end of the day kind of thing?
Absolutely. I mean, it may be more efficient. It may be more complete, and involve a lot less paperwork to simply provide the records that they're looking for without triggering FOA. What you can't do is tell them they can't submit FOA requests.
Yeah.
But
no, I understand.
yeah.
But it
Absolutely.
does feel weird trying to talk them out of it. It's not something that I've ever done. I've never done it that extreme, but just some data, like you say, most data is readily available. There's two questions in chat. They're not directly
Okay.
related to this slide. Kind of leave it up to you if you want to take them or not.
I'll take them.
Um,
Yep.
the first one is from David, and either David or Aaron, you guys can jump on and feel free to explain.
Yeah,
David says he has a
I can just
question.
ask Tom if that's okay.
Go for it. Go for it.
So, in California, there are state boards that vote on various regulations, and there's a law that prohibits the members of the board, from talking with each other about board business outside of the actual board meeting itself. I
Yep.
assume the intent of that is to make sure there are records for all decisions that are made that are publicly accessible. And I'm wondering, does Maine have a similar requirement where if we have a state board or commission with some regulatory authority, are they prohibited from discussing business of the board outside of their scheduled meetings?
Okay. Yes, excellent question. We'll talk more during meetings, but I'll just address this really quick. First of all, there's no state overriding law that applies to every agency that requires certain documentation of decision making. There may be something specific to a particular board or a particular situation, but there's no like single law that says every state agency and commission and board in the state of Maine must meet these documentation requirements. So not talking outside of the meeting for FOA would not have to do with documentation. What it would have to do with, in terms of FOA, is not having a meeting outside of the formal public meeting, and ex parte communications between board members related to the business at hand could be deemed a meeting outside of the actual board meeting, which is not allowed. But it doesn't have anything to do with documentation for FOA. Does that answer your question?
Yeah, thank you.
Yeah. Was there another one?
Yeah, there was one more from Aaron. How does FOA interact with retention schedules? What if we get a request for a record that is past the point of where we are supposed to keep it?
Yeah.
And how exhaustive of a search do we need to conduct?
Okay, great. We're going to talk about that in a couple more slides, so I'm going to hold on to that question. All right, so are we good here at this point? So basically what this slide is showing you is the steps that the public can expect to be taken after they have made a request. And then, as soon as a request comes in, the question comes up, what responsibilities do you have for responding to a particular request? And again, I always start with, well, is it a FOA? Is it going down the FOA track? Or is it going down the communication policy track, which was Tom's point earlier, when you've got the information at your fingertips and the person is standing there and you can simply provide it to them pursuant to your communication policy, FOA doesn't have to come into play. So that's always the first question. And then the second question that really impacts how this works in the real world is how centralized the response system is that you're tied into. I know Tom told me that in our audience today, there's probably town and city planners, there's state employees, or maybe contractors from the regional counselors, the regional councils. So you all are locked into different systems in terms of who you report to and how they work with this kind of thing. But how centralized the response procedure is going to make a huge difference. Who is actually doing the communicating with the requester? Is it someone from the town office? Is it your regional agency executive director or staff? Is there a public access officer, or are you expected to communicate directly with the requester. These are the kinds of questions I would have if this response procedure is not clear to you in terms of who does what. And it may not be well defined. You know, in some situations, it's extremely well defined. There are clear policies for how FOA gets handled, how the communication policy operates, all of these things. And then in other situations, I think you can feel really sort of like on your own, which is not a good place to be, because FOA provides a judicial remedy. Okay, they can go to court and sue you. And so you don't want to be alone in that situation. So that's the second big question I always have. What's the response procedure? How centralized is it? What's expected of me? And then finally, like, if you are the one who is going to bear the burden of actually responding to the FOA requests all the way through, then you've got to remember what your steps are. You've got to receive and acknowledge receipt. You've got to have a way to track what you're dealing with so that you know where it stands, because we have limited time. We have a timeline. You've got to be able to clarify the request, either deny it or produce it, provide an estimate, do the search, do a confidentiality review, figure out the time expense, do the billing, and finally produce. It's so I just don't like to see anybody feel like I'm on my own on this, because that's a lot. And if you are feeling like, you know, this is being put on you alone, it's really good to, you know, talk to your agency about improving the process. So I do want to talk about records management, and I'll address that question that came up a little bit earlier. Obviously, the goal of the Freedom of Access Act is to provide a mechanism for accountability. And, you know, we consider this a core feature of our democratic governance, that government is not conducted in secret. And this is just one mechanism to promote that kind of accountability. But it's really an impossible goal if there's no records management and retention, because you may have a right to access to records, but nobody can find them, or they're gone. And so it doesn't make any sense if we don't follow, as well as a good FOA procedure for responding. There should also be records management planning within the office related to the records that are being produced. So, you know, the basics about records, at least in the government setting, is that they have a life cycle. Everything that comes across your desk has a life cycle. It's created or received. It gets used and you maintain it during that period of usage. And then it gets a disposition. And there are different dispositions for different kinds of records. And legal disposal is based on this value matrix that gets applied to every record. And the considerations are the legal value, the historical value, the administrative, and then the physical value of the record. So within that value matrix, a record may be deemed a very low value and have a very short or no retention requirement. In other words, you know, it's you came into your email, it's nothing that fits into any retention schedule that has any long-term or medium-term or even short-term requirements, and it will be disposed of. It could be disposed of immediately. Then on the other end of that spectrum are the records that have our historical value to the extent that they are archival and should be retained permanently. And in between, we have all different kinds of retention periods. And hopefully most of those are contained in retention schedules. So all of this retention and records management is governed by the state archivist, according to 5 MRS section 95B. And the state archivist website online is an excellent resource for all the ins and outs of records management, and all of the schedules can be found on the archivist website on the records management pages. So you can go in there and look and see different levels of government, different subdivisions of government, local records, county records, the police records, the school records, and then all the state records too. And then just go through these lists of different kinds of records and see how long they need to be retained and what the disposition is. Many are, once the retention schedule has been met, lawful destruction is the disposal for many kinds of records. So how this is relevant to you in the sense that you want to know, what am I supposed to be doing with all these records that I either am receiving or creating? And what do what kind of system do I have to have in place so that not only have I got my records organized and I can get at them, but when they have met a retention schedule and they're subject to disposal and I don't need them anymore, that they actually get disposed of. Because we operate with a assumption that keeping everything forever is not only expensive and inefficient, but also opens an agency to certain liability. Because if you get a FOA request, and let's say the FOA request goes back, I want records all the way back to 20 years, and you have all these records that go back all the way 20 years, but you could have disposed of them 10 years ago. You could have destroyed them 10 years ago because they had met the retention requirement, and they were subject to lawful destruction, but you kept them in bankers' boxes in the cellar somewhere. And that's a real case. That's a real scenario. Because you have them, even though they could have been lawfully destroyed, you must now search and produce the responsive records to that FOA request. So if you have them, even though they could have been destroyed, and you get a FOA request and they're responsive, you now have to produce those. So again, these are questions that you should have in terms of the context of your work environment. Is there a mature records management program in place that provides training and support for how these records get captured, how are they being retained, and then the disposition? And if not, I mean, these are questions to bring forward, because I know the amount of records that I receive and create is just phenomenal. And Eric, of course, has just been such a support to us in state government. And Eric, I don't know if you want to say anything about the records management aspect, but we are leaning heavily on IT support in order to sort through some of these massive FOA requests that the state is getting now. And we have always had some big ones, but I would say that now, even just based on the explosion of information and the use of AI, without the IT support, we're really in a bind. And I hope Eric has a little something to say.
Yeah, Brenda. So for everybody's benefit, what Brenda's been talking about, the state archives record schedules, I went ahead and dropped it into the chat. The link to the records management section at state archives overall. and then there's another link that's specifically for local government agencies, and another one for state government agencies, and the fourth one for state government general schedules of things, common things like administrative records versus agency specific records. So depending on your interests, you could explore those at another time, but it's good to, as Aaron pointed out, Aaron was aware that there are record schedules. That's the first step. Everyone should be more educated about that, so you have an awareness. But then, as Brenda pointed out, if you've got it, there potentially have to be produced. So that's that point. You could check the chat links. But on the IT support and the electronic records, of course, now we have a mixture of the old world of paper records and then the new world of electronic records, and often you have both. You have a paper copy and then you have an electronic version of the same thing. So sorting all that out is important. My role is only with state government agencies. And Brenda's been doing her role for 13 years and me for 16 years. And in my role, I help over 100 people a year with state agencies. So I was curious how that's going to play out. Maybe at the end of this discussion, we can talk about. I know the new Maine Office of Community Affairs is a new office that took like 7 programs and functions from various places and put them into one agency. But then you have a lot of local and regional connectivity and liaison that's helps achieve the mission. So maybe at the end we can talk about if you have a FOA request, how. I mean, the advice that I give is specific to state agencies, and it's peculiar to our platform, which is Microsoft Office. A lot of towns, use other, non-Microsoft platforms, maybe like Google Mail, Google Docs, Google Meet, and we don't do that in state agencies. So I don't have any advice or help with those kinds of things. But anyway, I wanted to point out that what Brenda was talking about, the importance of the record schedules, is in the chat.
Great. Thank you so much, Eric. Are there any other questions at this point?
I always have questions. It happens every time, it seems. And I may have already asked the two of you this in some form, but maybe I wasn't satisfied with the answer. I don't remember. So we have some regional councils on this call, and we have employees, and we have some consultants on this call, true private consultants. So getting to Eric's schedules, if let's say you're a private consultant or your regional council, and you are doing work for a town, and then you turn over and then you do some work for the state. Do you have a different retention schedule for those different tasks?
Eric, what do you think?
Yeah, so both Brenda and I happen to be appointed members on the State Archives Advisory Board. I think both of us kind of put ourselves forward to volunteer for that, but then we got nominated by somebody in charge. So both Brenda and I have a deep perspective about records management. And if you look at the 4 links that I put 4 links in there. One of them is specific to local government agencies, and the other is specific to the other 2 are specific to state government agencies. But being on the Archives Advisory Board, I know that the Maine State Archives has really tried to, as much as possible, align those 2 so that the retention is consistent between what local government is supposed to keep and what state government is supposed to keep. So hopefully that partially answers your question.
Okay, thank you.
Great. Any other questions? All right, we're going to move right along here, and I want to talk a little bit about FOA's application to public meetings. So we're leaving records behind for a minute. And again, here we're talking about public proceedings that have to be open to the public and any person permitted to attend a public proceeding with the goal of open decision-making of covered bodies. And these are meetings that concern the transaction of any functions. Actions have to be taken openly. Deliberations have to be conducted openly. No clandestine meetings. This does not mean that members of a board can never talk to each other outside of a meeting. But those kinds of conversations are only prohibited if they defeat the purpose of the statute, which is open meetings and open decision making. And also, I just want to be clear that these requirements on meetings apply to covered bodies. So for instance, your local school board, your local select board, state government commissions, different kinds of bodies. But what this does not apply to are staff meetings within your group, that kind of thing. So so FOA gives certain rights to members of the public concerning a public meeting. They can attend, they can get minutes from the meeting, but FOA does not require that the public be permitted to speak at a meeting. There are certain rules for different kinds of bodies that may require that there be public comment, but the Freedom of Access Act doesn't create that. If let's say you're the member of the public and you're going to your local school board because you're interested in some of the issues that they're going to talk about, you can record the meeting, you can broadcast the meeting, but you can't interfere with the meeting with your recording. You can get advance notice of when and where, even in emergency meetings, if that's practicable. And then again, there is a judicial remedy. Any person can challenge the final action taken in executive session and have the court declare it null and void. There has to be notice of these kinds of public meetings. So the council's boards, committees, and subcommittees that are subject to FOA, except for executive session, have to conduct their meeting in public. There has to be notice in ample time, reasonably calculated to notify the general public. And there has to be a record of the meeting, but this is a minimal record. This is not running minutes or necessarily a recording, transcript or anything like that. Just some basic information about the meeting is required by FOA. FOA also has a provision that allows for remote meetings and has a few requirements there in order for those to be legal under FOA. I'm going to go pretty quickly through this. And again, FOA is setting a baseline for how public meetings have to be conducted, but often bylaws or local policy or even statutory requirements can bring in higher standards or just more steps that have to be met. But FOA provides a baseline. And then, there's a lot of things that FOA does not address. And I just started a list of some of the questions that I often get that FOA just doesn't address at all. What about the agenda? There's nothing in FOA about an agenda. So FOA doesn't cover everything. And then what are the situations where the members of a body can stray into rough waters and potentially be accused of having an unlawful secret meeting? And I just again listed some of the situations that I've had some contact with and questions I've had. And this does come up, for instance, a few of the members of the school board are going to talk out in the parking lot after the meeting about the business of the meeting. What about if they're sending encrypted private messages back and forth, either during the public meeting, I've had that happen also, or at any other time. And again, we're talking about the members of a body that's subject to FOA. So this is not internal communications between staff members, for instance. So you can see there's a lot of ways that that you can go wrong. And always the goal is to deal with the perceptions, because the perceptions themselves can sometimes be worse than the actual reality. And anything that can create mistrust or give an illusion of secrecy or any of that kind of thing is something people need to be concerned about, because it can be very damaging. The exception to public meetings is executive session. And executive session can be called for a very limited list of grounds. It has to fit into one of these categories. And there are also procedural safeguards in place to ensure that going into executive session has a few speed bumps on the way. For instance, it has to be a supermajority vote of the body to go into executive session. And all the decision-making, the final orders or that sort of thing have to be motioned after the executive session in open meeting. It's important to note that the Freedom of Access Act has a penalty provision for willful violation. And that I just note that it is a Class C crime to intentionally remove, alter, or destroy public records. And it's a Class E crime to violate the record retention law. Now, I don't know that any prosecutor has ever brought a case for that, but it's good to know that the legislature was serious enough to put penalties in there. And then here's the one that really matters most of the time. Let's say there's a denial of access to public records and the requester appealed to Superior Court. The requester is going to probably allege bad faith on the part of the agency. And if bad faith is found by the court, reasonable attorney fees can be awarded if the plaintiff substantially prevails. So something to keep in mind when we're talking about pitfalls is that all the communicating that you are doing about a FOA request is potentially going to be the subject of a lawsuit. And you really should be writing for the judge. In other words, everything that you put in your communications related to a FOA or having to do with the requester or anything, you really ought to keep in mind that a judge could be reading this and a judge may be ruling on based on these communications, whether or not your agency demonstrated good faith or not. So it's that's another pitfall where we often we're communicating so much, we're writing so much, there's so much email, it goes by so fast that it's easy to forget that everything that we're potentially writing not only could be subject to a FOA request, could be broadly disseminated, but could also be the basis of a judge trying to determine whether our agency has demonstrated good faith or not. So I think that's the end of my slides. And I would be happy to answer any other questions that might have come up.
If anyone has questions, this is your chance. If not, you're going to have to listen to my questions. So I hope that someone has some questions here. I mean, most of the, there's so many hypothetical situations out there. Okay, David, go for it.
Sorry if you answer this and I may have missed it, but does FOA apply equally to Maine residents and non-residents? For example, if somebody identifies themselves as being from New Jersey, but they're working on a news story comparing the way several different states address a particular topic, would they be able to invoke the same FOA process that a Maine resident would?
Yes, there's no distinction between the residency or any other identifying aspect of the requester. We don't have categories at all, and there's no limitation. So yes, they could be from out of state.
Okay, thank you.
There's a couple of questions in the chat, Tom.
Oh, was there? Okay, Ben, thank you. Yeah, my brain is still always at this, probably where Ben's going. I haven't even read the question yet, but maybe a slightly different angle than the question Tom asked. But as a private sector planner, I have been advised that someone making a FOIA request cannot make that request to me or anyone else at the firm. But if they make the request to a town or city that we work with, that the town will then send materials and communications we have been party to or prepared. In other words, the municipality is the entire entity subject to the FOIA,
Yes.
not the contract planner firm. Okay.
Yes, I would say that's correct. It's the agency, it's the government agency that is subject to FOA. So the request should be directed to the agency. Then there are situations where the custody or possession of the government agency will include the records that a contractor that worked on a project for the agency may have related to that FOA request. And it's always depends on the circumstances, how far that goes. But you may be asked for records that you created relative to that public project, but the request itself has to go to the agency, and the agency is responding. It should not go directly to a private entity because you're not subject to FOA. But you may be subject to some of your records may be subject to FOA because they relate to that public project.
Yeah, thank you. I think that clarified it for me too. I guess I didn't know that. I thought the resident could go right to the source and request that data. So I learned something. And I would probably throw any sort of a quasi-public entity in that. Probably throw the regional councils probably in the same boat, I'm assuming, where regional council wouldn't receive the FOA.
They may. I mean, they may have records. The regional council. I don't know. It depends. It depends what the request is for.
Okay. Okay. Yeah. Joan.
Yeah, I should jump in. Just having spent a couple of decades working for a regional council, we always treated, we were a quasi-municipal entity, so we always adhered to the records disposition requirements that are in statute. And James, I would err on the side of caution and assume that because you are a public entity, that you probably wouldn't get the same protections that a private sector entity like Ben's Corp company would.
Okay. Thank you.
Can I ask a follow-up question? Thank you, Joan. You'll see in communications from municipalities, there's a very common FOA disclaimer that are used in the body of emails. Would you recommend that regional councils also employ something similar for communications?
I do recommend it. It just gives a heads up to people who are communicating with you, who never in their wildest dreams would ever think that anything they're sending to you might be a public record. It gives them a heads up to have a little discernment. I have one in my email signature. It's just very basic. And again, it's just a heads up. It may happen, and it just lets them know that.
Yeah, I have a question, follow-up question. the regional councils, what kind of email does your end in? Is it end in .gov or .com, or are you considered a,
.org.
What was that?
.org.
Yeah, so are you considered a public entity or a
We're
public
nonprofits.
private? I'm sorry, say
We are
again.
non-profit organizations.
Their membership is made up of municipalities. That's why in my organization, which is not where James is, we always characterize ourselves as quasi-municipal.
Yeah. I would say quasi-municipal, Eric, is the best way to describe it.
Yeah, so I guess it gets back to Brenda's question, FOA applies to governmental entities, and so how does that apply to if you're like quasi-governmental, but also Aaron Wilson has a question in the chat also.
Sure. Are all the guidelines for determining how long a reasonable time is to get the records together? Are there any guidelines? So time on that, Brenda, you probably see it all over the place.
It is all over the place. So reasonableness depends on the circumstances, and that is going to include factors such as staff availability, how complicated the confidentiality review is, accessibility of the records, like are these in 10 different repositories going back 50 years, how complicated is all of that? But, I do think that FOA should be addressed as promptly as possible. Because again, your ability to prioritize it, the professional nature of how you respond to it, all of this goes to the good faith of the agency. And that is the thing you are protecting. And that's what you're protecting by having a good process in place and not pushing this off. And it's hard because we don't, most agencies do not have dedicated FTEs to deal with FOA. It's all of us who have a full-time job already who are doing FOA on top of what we already do. So it is difficult in that sense, and I think a court takes that into consideration, but you still want to be showing your good faith in every possible way. Any other questions?
I don't see any others in chat. I have one that I had never thought of until recently, but for volunteer boards, all those, many of those volunteer boards, I think you might have used the word qualifying board or something to that effect, meaning it may not apply to every municipal, group, but what happens, and I may have experienced this when I was on the planning board, but you have residents that are maybe more secretive with emails and so forth, communications and so forth. And so there may be, probably use the word uncooperative with the FOIA. I guess that's the best word for it, but you may not get a response from them at all. So the town is, feels like they've done their part, but they may not have satisfied the request.
So my understanding of your question is, what about like appointed boards, maybe on the municipal level?
Yep.
Maybe it's a time limited appointed board to research options for a new school building or whatnot. And they are all operating with Gmail accounts.
Yep.
They are not necessarily wanting to have public meetings, or they're not necessarily limiting their communications to within the public meeting. They're not managing their records necessarily. And then the FOA request comes in because there's all kinds of controversy about this topic, and they don't want to produce. And the FOA request is going to go to the municipality, and the municipality is responsible for production. And so let's just get, the worst case scenario is this rogue appointed board won't produce anything, and the requester sues the town.
Yep.
And the town now has to go before the judge and explain why they can't get access to records. And the records that are being created by this rogue board relative to the transaction of government business, right? And they're in their custody, they have them. They're public records, they should be produced, but the town lacks certain things. And what it lacks is, first of all, standards for the training of their boards. It should be a fundamental part of training that when you come onto this board, you're allowed to use this email account. All of these records will be managed and transferred to the town's possession in a certain way. These are the rules around the conduct around the meetings. You know, all of this could be trained, and there could be consequences for violating those requirements. But if none of that's in place, you have a very immature organizational structure, and you're going to have a lot of problems, but ultimately the town is responsible for having those records.
Thank you. What is the entry point for a person to make a FOIA request? I think you just answered that, right? The government entity is probably the answer to that one.
In terms of so it should be, well, yeah, you don't have a right to make a FOIA request to a private entity. Right. So you're going to go to whatever government entity it is you think has the records or should have the records.
And kind of continuing on Aaron's question, and I think I know the answer, but that request for as far as the point person, it can be made to any government employee. If you want to make a request,
right. Right. The goal of the statute is to make it easy to make a FOIA request. There's no form required. It doesn't have to say FOA on it, you know. It can be made to anybody, but I strongly encourage that it be clear who is the point person. If you're going to have a public access officer, who is that person? And I tell requesters, don't make your request to the janitor at the school and think that that's going to be an efficient way to get your, request satisfied. Go to the top, go to the superintendent and let them deal with it.
But if a resident walks into town hall and you have, the weekend clerk covering the counter and they've never gotten a FOIA, they should still accept it and receive it.
They should.
Right.
And this, just having a simple procedure in place where that can go into the tracking and it can be, and then directed to wherever it needs to go. A little bit of process goes a long way with ensuring compliance with FOA.
Yeah. And then more of a comment here from Ryan. What Brenda is saying right now about rogue boards is the most interesting part of this webinar thus far. I'm not a fan of the word rogue because I think many times it's not intentional. I don't think in my experience.
I've seen it intentional.
You've seen it.
I've seen it all, Tom.
But sometimes it's truly people that just don't. I mean. We have board members that have to get driven to the meetings. You know what I mean? They're just elderly and it is sometimes.
Can I just give this one little tip? And this is kind of obvious. Maybe other people know this too, but we do often have to use or ask our board members to use their personal email accounts because the municipality may not have the capacity to give everybody a government account. And I recommend always having a government account that they can copy everything onto. So if they're being allowed to use their Gmail account, they should be required to copy onto that government account everything that goes through related to the business of the board. And that way it's on your server. And if that's meticulously followed, you can rely on that policy when it comes time to do a search and you're going to the government server. If it's not trained, if it's not required, if it's not followed, that's a different story. But that's one way to get around that personal email accounts that you don't actually have physical access to.
Okay, excellent. And then Aaron is asking, oh, sorry, Joan, go ahead. Apologies.
I had my hand up and then I took it down
You're
because
good.
Brenda, I thought you were going the same direction I was going. Can you expand further about discovery for board members that are using, or employees that have to use their personal cell phones? How much, or their personal computers, how much of that device is open to discovery under a FOA?
Right.
Can
Well,
the entire device be looked at, even if it doesn't have the municipal subject line?
Right. So let's make a little distinction, Joan, between your basic FOA request, just, it's just a basic FOA request, and what you just used the term discovery, which is a legal term for access to records within the context of a court case. And then above all of that, I would put forensic access to a computer or any repository whatsoever. Within the context of FOA, generally, there's no forensic aspect to it. In other words, I can ask for information, I can ask for certain records, I can ask for metadata, I can ask for this and that, but I don't have the right under FOA to demand some forensic level search of someone's device. It would really have to go much, much further to like allegations of intentional withholding and with evidence and all kinds of other stuff, or intentional destruction, and then by then you're probably involving law enforcement. So they're not going to get access, they're not going to get your device, in other words, in FOA, all right? And the other thing to keep in mind is FOA is only providing access to public records. So all your private stuff, in other words, doesn't have anything to do with your public business. And there may be some mix, like let's say, heaven forbid, you have to use your personal cell phone to conduct some business. And there's some email, there's some other documents on there that and in addition to that, there's all your personal email, all your personal documents, your texting, all this other stuff. Just because there may be some government emails on that phone doesn't make the phone now accessible. You would just be taking those government emails off of your phone and providing them, but the rest of what's on the phone does not suddenly become accessible. You still don't want to be in that situation, but it does happen. This is why I say, if you've got a government account that you can copy everything over to and get it off of your private either device or phone or whatever, you're in a better situation.
Great. Thanks for the clarification.
Yeah.
There are was a question. Well, this maybe we can handle afterwards, but Aaron, good catch. I saw that when I was talking to Brenda and Eric a week or so ago. The FOIA web page contact list doesn't have our newly formed MOCA yet. So
Tom, would you send that to me and
okay.
I'll have the webmaster put it on.
Okay, sounds good. Thank you.
Yeah.
Thank you, Aaron. And then I guess that may be it. Ryan had a comment about using a mail service other than Gmail called Proton Mail, but I guess their town, some of them are using that now. Okay. Anything else? I guess we've run out this hour and then some. Extremely helpful, Brenda. Eric, thank you. Eric could go on forever, but that's probably more of a state audience. So any questions, feel free to, you can send them in at any time. And we will have our next webinar Friday, March 6th. Please send in your suggestions for topics. And if there's nothing else, everyone can have a great day, and thank you, everyone. Oh,
Thank you.
education credits, AICP education credits, those are pending. So only because their website where those requests are made was down at the time. But Aaron from, I'm sorry, Joan's gonna have to help me here. Aaron from Yarmouth. What's the last name?
Worko.
Okay, it's Yarmouth, right?
Yes.
Okay.
Yeah.
Okay. She's coordinating that. Apologies, I kind of spaced out there. So I don't know if you want. We do have all the attendance here, tracked. So maybe I'll just send that to her. I'm not sure how we'll get that, but once that's ready, she will ensure that those credits are made. Okay. Thank you, everyone. Have a great day. A great weekend.
Bye-bye.
Thank you.
Thank you.